post hoc justifying it by science. All right, so Sam, you got involved in this. So tell us your story and flesh out what's been happening on the legal front and where this is going to go. And I want to return to Carl too about the funding issue after that.
Sure. So good afternoon, and thanks as well for having me on the podcast. This is very much terra nova for me. I'm not a constitutional lawyer. I never saw myself getting involved in a constitutional case of this magnitude. And I think I've said before elsewhere that constitutional law was my lowest mark ever in school. And yet here I am at the forefront of this challenge. I think like my clients, like Carl and like Sean, I also felt compelled to do something. If you see there's a problematic trend happening and you have a means to affect some sort of a change and you do nothing about it, I think in your own way, you're contributing to the problem. And everyone has a different threshold of getting involved. And quite frankly, my threshold, I sort of crossed that threshold at the mandatory hotel quarantine, which is a policy that I never would have imagined ever witnessing in a Western democracy. The idea that somebody would have to quarantine pending a result of a virus that, quite frankly, we've seen in some iteration before was frankly disturbing to me. And that's really what propelled me. And I was very fortunate to get connected with Sean and then again with Carl. And it's true, Sean, Carl, and I in many ways have become our own little family. And we've been very fortunate to be supportive of one another in what has been an extremely grueling 7-8 months. This case really started Christmas Eve. I suppose you made it a present to the government, and we're still in the midst of it. And here we are in August, and just today I'm submitting my final materials to the court for the application. So it's been an extraordinary process, and we've learned, as you've come to learn, very extraordinary things along the way.
Well, can you no one listening knows how a case like this proceeds. So could you walk us through the basis for the case, the nature of your challenge, how the government lawyers are resisting this, and lay out the story of the court battle and where it's headed?
Sure. So fundamentally, there's sort of two ways in which litigation proceeds through the court system. The one way is an action, and an action is sort of what most people come to know in like TV courtroom dramas, where you have a judge and you have a witness, and there's this idea that people are yelling and cross-examining, and they're getting evidence orally, which is what we call viva voce evidence. That's not what's happening here. This is proceeding by way of an application. And an application is largely a paper-based record. So what happens is people put in evidence to the court, and they do that by way of an affidavit. And you can think of an affidavit as a story. And you get stories from the applicants like Sean and Carl about how the mandates have infringed their charter rights. And you also get, stories, I'll just call them a little bit more informally, from experts who talk about the science and different policy considerations. And then each side has to do that. So both sides have to produce their evidentiary record, which is, as I mentioned, exclusively done by paper. And then what happens is we participate in what is called the cross-examination. In an action, the cross-examination is done live in front of a judge, and the judge is there to assess the credibility of the witnesses and weigh testimony. In an application, which is what we're doing, that is done with privately in a boardroom with a court reporter, and there's endless hours of cross-examinations based on what people have said in their affidavits, their story. And so a lot of the evidence that Rupa's referring to came out in the process of that cross-examination, because as you know, our system, our justice system, is premised on the adversarial context and the idea that if competing evidence is tested, the truth lies somewhere and the truth will come out. And we spent May and June, literally 2 months, just exclusively in cross-examination. We then take the affidavit records and we take the cross-examination transcripts. We file that with the court, and then we appear at a hearing. And in that hearing, we make reference to the evidence both in the affidavits, in the expert reports, and also in the cross-examination transcripts. And it's just submissions from lawyers in front of a judge.
Okay, so what's the nature of the challenge? The government put in these mandates, and they were mandated and required, and you're objecting to that. What exactly is the objection, and why are you even vaguely allowed to do this, let's say?
Well, I should hope we're allowed to do this, or else we have a much larger constitutional crisis than I currently think we do. But, first and foremost, there is a prima facie infringement of Sean, Carl, and those Canadians who are not vaccinated, a prima facie infringement of their Section 6 charter right, which is the right of mobility. And I think it's one of the most fundamental rights that we have in the Charter. It goes to the very essence of what it means to live a dignified existence, the notion that, a man or woman can get up and move about their country and leave their country at their will. And that's been directly engaged in this charter challenge. And in a context, quite frankly, that I've never seen before. A lot of the Section 6 cases deal with issues like extradition, deportation. I've never seen a case like this, that a government policy in reference to a public health mandate has had the effect of preventing their own citizens from moving between provinces or from leaving their country. In fact, I can tell you right now, I have not found a case like this other than a case in Newfoundland in the context of the COVID-19 pandemic. And the second thing, which I think is also very novel here, is the government has effectively created Sophie's choice, right? They're asking Canadians to do a little bit of horse trading with their charter rights. You cannot simultaneously exercise your right to travel while also exercising your Section 7 right to protect your bodily autonomy. What do I mean by that? You need to make a decision. You are either going to get on a plane and get vaccinated, or you are not going to get vaccinated and you're going to forfeit your right to use federally regulated transportation system. I think that's actually constitutionally unprecedented. I've never seen a scenario where a government policy has created such a direct conflict, such that it coerces you to choose one over the other. And let's be clear about that. Sean and Carl were coerced into not traveling because they wanted to protect their decision-making over what is an inherently private choice, i.e. vaccination. And so both of those issues are very much engaged, and it's on this basis that we've brought this application.
Okay, and so what's the fine, I got it. So what's the government counterclaim? Now, hypothetically, the emergency was such that the science indicated that the government could suspend Canadian charter rights. Okay, what kind of evidence do you need? When can you suspend rights? And when you suspend rights, by what principles are you allowed to suspend them?
Well, we were on a quest to answer a lot of those questions. As you know, obviously, no right is absolute. And if the government has a compelling objective such that they may need to infringe a charter right, they're entitled to do so if they come to the table with the right type of evidence, right? There's a reverse onus. I mean, once my clients show that their rights have been breached, the government then has to go to court and convince the court that they were justified in doing so. And that's where this fight is really happening. What is the justification? What is so compelling about the risk of the unvaccinated flying that you believe it is permissible in our democratic society to force unvaccinated people into making the decision that I just described? And I can tell you that having been living this case for the last 7 months, the approach the government has seemed to take is the casual application of general scientific principles to the transportation sector.